This is Bloomberg Law with June Grasso from Bloomberg Radio.
There's been a remarkable showdown between the Trump administration and the federal judiciary in a Washington, D.C. courtroom this week. Last Saturday, Judge James Boasberg ordered the government to turn around any planes that were flying alleged Venezuelan gang members to a prison in El Salvador based on a law used only in wartime. But the planes were not turned around. And since Monday, the judge has been demanding information on the times of the flights to determine whether his order was knowingly violated. But the government has repeatedly refused to give him that information. Here's President Trump's response on Friday.
Mr. President, do you think you have the authority, the power to round up people, deport them, and then you're under no obligation to a court to show the evidence against them?
Well, that's what the law says, and that's what our country needs, because unfortunately, they allowed millions of people to come into our country.
Perhaps even more stunning, the U.S. Attorney General Pam Bondi on Fox this week challenged Judge Boasberg's authority.
This judge has no right to ask those questions. You have one unelected federal judge trying to control foreign policies, trying to control the Alien Enemies Act, which they have no business presiding over.
The legal issue at the heart of these hearings is Trump's unprecedented use of a law used only 3 times in our history during wars to deport hundreds of alleged Venezuelan gang members. My guest is constitutional law expert David Super, a professor at Georgetown Law. David, I want to put Friday's hearing into context. This has been a week-long struggle by the judge to get some basic information from the government about when the flights took off and landed. And he's moved the deadline over and over again to give them an opportunity to comply with his order, and they haven't. What's going on here?
The only conclusion that I can draw is that they violated his order deliberately, and they're trying to avoid revealing that. The questions being asked are very simple questions, and if the answers are not embarrassing, there's no reason not to disclose them. No terrorist can harm a flight that occurred almost a week ago and is long since returned to ground. There's no national security implications here. It appears that there's security implications for particular officials who may not have acted appropriately.
The Attorney General, the top law enforcement official in the country, said that the judge has no right to be asking for specifics in the case in front of him.
That's very disturbing. Any lawyer understands that judges have a right to protect their own jurisdiction. That's true of any court worthy of the name. The judge issued an order that was not complied with. If it was an accident, that's certainly something the judge is entitled to know about. And if it's deliberate, the judge is entitled to know about that.
At the hearing on Friday, Judge Boasberg started with a warning to the government lawyers, telling them they need to be careful how they act, cautioning them that their professional reputation is the most valuable thing they have. It seemed like the tone was very different on Friday.
Yes, it was. Judge Boasberg issued an order that he believed to be correct on Saturday and assumed, as judges do when they issue orders to federal officials, that those officials would follow it. The officials did not follow it, and if it was an accident or a miscommunication, they've had the better part of a week to show that. The fact that they haven't and apparently can't show that it was an accident suggests that this is contempt of court.
You had the AG, the president, and others criticizing Judge Boasberg. Trump called him a radical left lunatic of a judge, a troublemaker and an agitator, and called for his impeachment. And on Friday, the judge seemed to want to set the record straight. He actually got the government attorney to concede that he understood the judge's verbal order on Saturday to turn the planes around. So he specifically got that on the record.
Yes, I think he got a number of very important admissions from the Justice Department lawyers on the record that undercut things that have been said in the media. The Justice Department lawyer admitted that the judge had clearly ordered the planes to be turned around well before 7:25 that evening. He admitted that this was a mandatory order. He said he passed it along to the relevant officials. This makes very clear that the timing that the administration has been raising is not correct, and that the administration's notion that this was somehow a temporary order or an order that was superseded is not true.
The government's language has been defiant at times, and Boasberg accused the government lawyer of using intemperate and disrespectful language that I can't remember seeing from the United States in court filings. And he said he's going to get to the bottom of it, whether they violated my word and who ordered this. Does it seem like a contempt citation is coming?
Certainly. The judge has two questions he has to ask concerning contempt. First, was his order violated? And second, by whom? He has apparently established that the government understood what his order was and is pressing the government for details about exactly what was done that might show that there was indeed a violation. But he's also pressing for information about who did what, which would allow him to identify which individuals might be in contempt of court. The lawyer who spoke in court insisted that he passed Judge Boasberg's order along promptly to immigration officials. I take that to mean him saying that he is not the one who is in contempt of court. Judge Boasberg would like to know who is.
The judge has yet to rule on Trump's use of the Alien Enemies Act, but he called the Trump administration's arguments about the extent of the president's powers under the act a long way from the intent of the law and awfully frightening.
Yes, the plaintiffs submitted affidavits from family members of many of the people who were sent to El Salvador indicating that they were not gang members and never had. In one instance, the family member described the tattoos that his brother had and indicated that these were things that had no gang affiliation but were simply decorative. There's no indication in the record that this is incorrect, and the administration provided no hearing where anyone could correct misunderstandings of these tattoos. I believe Judge Boasberg is noting the absence of any evidence disputing what the plaintiffs have said and is coming to believe that a lot of innocent people were sent to El Salvador, a country with a history of torture.
The Trump administration maintains that cabinet secretaries are actively considering whether to invoke the state secrets privilege to prevent turning over the information on the flights. The judge gave them until March 25th to confirm whether they'll be invoking that. But on what possible basis could they invoke the State Secrets Act?
I can't imagine how. If the judge was asking for details of their negotiations with the Salvadoran government or some other national government, that could be plausible, but that doesn't appear to be what Judge Boasberg is asking at all. He's asking for dates about flights and for communication about that flight and his order within the Justice Department. It's not a state secret just because it is embarrassing some state official.
The talk has ramped up this week about whether there's a constitutional crisis. And you have President Trump saying, he's not going to defy a court order. But then he says things like, we can't let a judge do that. We can't let this happen. Have we reached a constitutional crisis?
We have, because the administration has been violating many court orders, not just this one. And when one branch of government declares itself free from the checks of the others, that is a constitutional crisis. The president keeps saying that he wouldn't violate court orders, but his officials do. So either he's completely incapable as an executive, or he is allowing his officials to disregard court orders.
So what can be done?
I expect that the officials who violated the order of Judge Boasberg will be asked to appear in court and explain themselves, and if they don't have an adequate explanation, I expect that they will be charged and very possibly convicted of contempt of court. It's very possible that Judge Boasberg also will issue further orders that make it more difficult for them to violate his orders in the future.
We started the week with Chief Justice John Roberts stepping into this battle between the Trump administration and the judiciary after Trump called for the impeachment of Judge Boasberg. Roberts made a rare public statement saying that impeachment is not the appropriate response to disagreements over a judge's decision. Looking at the escalation since then, did it make any difference for the Chief Justice to issue that statement?
The Chief Justice is using indirect and delicate language to avoid provoking a further crisis. Wise people would listen to him. So far, we've seen very little evidence of wisdom from this administration.
So there was confusion over the flight times, but now there seems to be added confusion because on Friday night, President Trump said he wasn't the one who signed the proclamation invoking the Alien Enemies Act.
We want to get criminals out of our country, number one, and I don't know when it was signed because I didn't sign it. Other people handled it. But Marco Rubio's done a great job, and he wanted them out, and we go along with that.
So the questions in this case continue, and Judge Boasberg has given government lawyers until Tuesday to explain why he shouldn't find that they violated his order to turn the planes around. And we haven't even gotten to the merits of the case yet. Thanks so much for your analysis, David. That's Professor David Super of Georgetown Law. Coming up next on the Bloomberg Law Show, for the first time, a judge limits Elon Musk's power, finding his dismantling of USAID likely unconstitutional. Remember, you can always get the latest legal news by listening to our Bloomberg Law podcast wherever you get your favorite podcasts. I'm June Grasso, and you're listening to Bloomberg. The Trump administration is facing more than 150 cases across the country challenging its actions. And many of the cases involve Elon Musk and Doge, which has moved swiftly to fire tens of thousands of federal workers, cancel grants and contracts, and generally dismantle the federal government. In court, the administration says that Musk isn't the head of Doge and doesn't have authority to give orders at agencies. But remember when President Trump gave a shout-out to Musk during his joint address to Congress last month?
I have created the brand new Department of Government Efficiency, DOGE. Perhaps you've heard of it. Perhaps. Which is headed by Elon Musk, who is in the gallery tonight.
Well, federal judge Theodore Schwang seems to remember. And he cited that in the first major ruling to find that Musk likely exercised unconstitutional powers, in this case by orchestrating the shutdown of the U.S. Agency for International Development. Joining me is constitutional law expert Michael Dorf, a professor at Cornell Law School. Mike, USAID was the first agency that Musk took his chainsaw to. Remind us what happened.
Musk and the Doge people went into USAID and they canceled a very large percentage of the contracts that USAID had with partner organizations throughout the world. They also displaced the existing leadership, and Secretary of State Marco Rubio assumed control of USAID, and they gutted the staff. Musk also actually tweeted that USAID was effectively dead, right? So this was an effort by Doge to essentially kill an agency created by Congress.
The judge found that Musk and his team likely violated the Constitution in multiple ways. Let's talk first about the Appointments Clause issue.
The Constitution sets out how officers of the United States are appointed. So-called principal officers, who are people who have a whole lot of responsibility, so think about a cabinet-level secretary, must be nominated by the president and confirmed by the Senate. There are also what the Constitution calls inferior officers who exercise considerable power but under the supervision of a principal officer. And they can also be appointed via that same mechanism of presidential nomination and Senate confirmation. But the Constitution says that alternatively, for an inferior officer, Congress can vest the authority to make appointments either in the president alone, the courts of law, or in the heads of departments. What the judge said was that Musk is exercising at least the power of an inferior officer, probably the power of a principal officer, but it doesn't matter which he is because he wasn't appointed in conformity with procedures. He was not nominated by the president and confirmed by the Senate. He was apparently appointed by the president, but the Appointments Clause says that can only be a mechanism for inferior officers if Congress authorizes it, and Congress did not authorize this. Congress didn't even create DOJ. DOJ is a creation solely of President Trump.
And the administration had said that Musk isn't the real head of DOJ and doesn't have the power to make these kinds of decisions. But the judge cited Trump's statements about Musk and Musk's comments and social media posts to demonstrate that, quote, he has firm control over DOJ.
That's right. It's essentially holding that even though at one point or another the administration has tried to claim that Musk is just an advisor, he was in fact exercising the power of the head of DOJ. Musk has claimed that he is the president in his address to the joint session of Congress, referred to him that way. He's referred to him that way in other statements. And so you can't just evade the Appointments Clause by having somebody be a de facto principal or inferior officer without, triggering the requirements of the clause.
So the judge also found that this push to dismantle USAID, which was created by Congress, likely violated the separation of powers principles.
Yeah, so this is the other key point of the constitutional ruling. The Constitution refers to agencies, but leaves to Congress the prerogative to create and destroy agencies. And the administration seems to have recognized this in another context with respect to the Department of Education. Even Secretary McMahon acknowledges that she can't dismantle the Department of Education on her own. That would require an act of Congress. Here, by contrast, Musk and to some extent Trump have effectively said they are dismantling USAID, and they can't do that, right? It's up to Congress to destroy the agencies it creates. They haven't literally wiped out USAID, but if Congress creates an agency and then the executive branch essentially guts it, that's the equivalent. And that's how the judge ruled in any event.
What is the practical effect of the judge's order when, as you said and as he said, the USAID has effectively been eliminated?
With respect to the Appointments Clause, the judge stayed his ruling for a brief period because he acknowledged that if the decisions that were effectively taken by Musk are now ratified by actual USAID officials, then that would render Musk a mere advisor, in which case there would not be an Appointments Clause violation, or at least not one that leads to invalidation of the underlying actions. With respect to the separation of powers argument, however, one thing he crucially did do was make an order that has an impact agency-wide. So the short of it is that the administration can't make further cuts to USAID. Some of the personnel will be put back in their jobs. But all of this, of course, is going to be subject to an appeal, which the administration has said it will take.
Even if they're put back in their jobs, the judge gave Rubio, 14 days to decide whether to permanently close the agency's headquarters?
Right. So the president and the Secretary of State, where it's an agency lodged within the State Department, do have considerable discretion about how to run and even structure an agency where Congress doesn't say exactly what you have to do. And so that's part of what the judge is doing here. He's saying that you can't completely close it, but you do have some considerable discretion, and I'm going to wait until you exercise that discretion and see, whether you've done so in a way that at least preserves the core of what Congress set up this agency to do.
This decision obviously is limited to USAID. It's the most direct ruling to date that Musk's role violates the Constitution. Does this decision have any impact outside of USAID?
Yes, the principle that the judge applied would apply to all of the things that Musk is doing with respect to, the entire federal government, right? So there's no difference in principle between Musk's unlawful appointment with respect to USAID on the one hand versus all the other agencies that he's been, going around and making decisions with respect to. But of course, other judges might reach a different conclusion on the Appointments Clause question. And even if they reach the same conclusion, there is this pretty big loophole that the judge allows for cabinet-level officials or other personnel within the agencies who are actually properly appointed to ratify the decisions that Musk has made so that they can render him advisory in the way that the administration has sometimes claimed he is after the fact, and thereby avoid, the judicial invalidation of everything that Musk and Doge have done.
I want to turn for a minute to this concern in the legal community about the Trump administration not following judges' orders, whether it be with regard to the funding freeze or rehiring probationary workers or the Venezuelan deportations. The administration seems to be either ignoring or delaying or skirting judicial orders.
Yeah, and that is a very, very serious issue. The administration, I think, is playing a little bit of a game that is in social media posts and elsewhere. They are asserting essentially a power to ignore judicial orders, but in actual court filings and statements, they have almost invariably claimed that they are complying, but they do so with, somewhat flimsy reasons, right? And so to the extent that there's like a sliver of a silver lining, I guess I'm glad that they at least feel the need to pretend to be complying when speaking in open court, because it strikes me that we would be in an even worse constitutional crisis if a Department of Justice lawyer stood up in open court and said to the judge, "Make me," and then the president basically said, well, the U.S. Marshals who are supposed to enforce judicial orders are part of the Justice Department, and I've instructed my Attorney General not to have them enforce the judicial orders.
Have other administrations acted like this with court orders? Not openly defying them, but not really complying with them either.
You can point to situations in which administrations have not exactly bent over backwards to comply with the letter of judicial orders. There are certainly cases in which administrations at least seem to try to comply, but were unable to because of resource or time constraints. I can't think of an administration that was so uniformly hostile to judicial orders and at the same time was asserting that it had the power to disregard what the courts told to do. The events that we think about in this context are pretty scary moments in American history. So there's the story that's told about President Andrew Jackson, who was unhappy with the ruling of the Supreme Court in one of the Cherokee removal cases and reportedly said, John Marshall, meaning the Chief Justice of the United States, has made his decision. Now let's see him enforce it. By the way, he probably never actually said that, but it's a good story.
It's a great story.
But this is a recurring theme in American constitutionalism. And it's because, as Alexander Hamilton wrote in Federalist Number 78, the judiciary is what he called the least dangerous branch, but it's also the least powerful branch. Unlike Congress, it lacks the power of the purse, and unlike the presidency, it lacks the power of the sword. And so ultimately, compliance with the law depends on good faith efforts by those in government who do control the levers of power to actually accept that there is authority in other branches of government. I'm not convinced that President Trump or the people working for him have that kind of a commitment to the rule of law.
Future cases will tell the tale. Thanks so much, Mike. That's Professor Michael Dorf of Cornell Law School. Coming up next, tennis players take on their sport. I'm June Grasso, and this is Bloomberg.
I think things needed to change. So it's a big day for tennis.
And not because of a major tournament, but because of a major lawsuit. Nick Kyrgios is one of the named plaintiffs suing tennis's governing bodies, accusing them of running a cartel that exploits players by capping their prize money, limiting off-court earnings, restricting competition from rival tournaments, and forcing players to endure a grueling 11-month schedule. Here's how he explained it to Sky News.
I felt like people knew that something was going on behind the scenes for a long time, and I think that, myself, Pospisil, Djokovic, we all wanted to do something like this, for the future of tennis. I know the players and myself and many other players aren't happy with the structures and everything that's going on in tennis at the moment.
And their dissatisfaction is apparent from the 159-page class action antitrust lawsuit filed by 12 named players and the Professional Tennis Players Association against the ATP and WTA tours and the International Tennis Federation. But conspicuously absent in the list of named players is 24-time Grand Slam winner Novak Djokovic, who co-founded the PTPA. He's been vocal about higher pay in tennis, where the gap in earnings between the top players who make millions and the lower-ranked players who are barely managing to support themselves is the widest in any sport.
The media is communicating how much does a Grand Slam champion win constantly, rather than, also shining a light on the players that are barely making a living from tennis.
My guest is antitrust law professor Harry First, a professor at NYU Law School. Harry, can you give us the basics of this very long complaint?
Well, the basic idea is sort of similar to other suits that have been brought. Basically, players complaining that those owners who are running the sport are getting a lot of the benefits and they're not getting their due. And mainly because the owners are suppressing the market for the players' services in various ways. And one of the ways being trying to exclude competitors that might be willing to hire the talent, these players, in competing leagues, competing races, competing tournaments, things like that. So there's exclusion, there's price fixing, and the talent, the players, the laborers, if you will, not getting their due.
They accuse the sports governing bodies of running a cartel and say professional tennis players are stuck in a rigged game, not on the court, but off it, where players are forced to endure grueling schedules, capped earnings, abusive and invasive investigations, and discipline, and have limited control over their own careers and brands. Of course, one of the top issues is money. In other professional sports, about half the gross revenue goes to players, but tennis shares less than 20%. But is this an antitrust issue?
Well, that's a really great question. It's sort of a no, yes, no.
Let me think about that. Okay.
How's that for good wishy-washiness? So really low prices for the things you are buying, or what economists would call the inputs, that in itself I don't think is an antitrust violation. Just like charging really high prices for what you sell is not really an antitrust violation. You have to have exclusion of competition for there to be an antitrust violation, and an agreement among competitors. So sometimes an agreement among competitors to buy things for a low price, that could be an antitrust violation, or an agreement among competitors to sell things at a higher price. That could be an antitrust violation, technically, because you have competitors who might otherwise either compete the price down if they're sellers, or compete the price up if they're buyers, like buyers of labor. If they were acting independently, you might have different prices, different outcomes, better for the party that's selling their goods or services, or better for us consumers who are buying them. So in a technical sense, no, as an individual seller setting your price, that's okay. It's bad if you do it in collusion, or a more graphic way is to call them a cartel. That's bad. And then there's a slight sort of twist on it. Although it is not bad in itself, if you're a single seller, to pay too much or pay too little, that's often a sign that you do have monopoly power. And so in a lot of cases that we're seeing, the parties are litigating the idea that prices are either too high or, in the case of labor, too low, and it will form the basis for a damages claim.
So, Harry, there's a price-fixing claim, and according to the lawsuit, a key method used by the tennis governing bodies to keep player pay low is locking them into this closed system of tournaments. And Larry Ellison, the billionaire, wanted to increase the total prize money at his tournament by $1.6 million, but the ATP and the WTA wouldn't allow that because they don't want one event to be paying more prize money than the sport's 4 marquee Grand Slam events. That does sound like price fixing.
Well, it's sort of a colorful example because it shows what price fixers who agree on what they will pay for labor can affect the price of labor. You know, here's even Larry Ellison can't pay what he thinks is a market price to attract talent to his tournament and compete in other tournaments. So that sounds really bad. The little problem with that is, what year was that that occurred?
2012,
Yeah.
A while ago.
So a while ago, outside the statute of limitations, technically. So it's nice to put in a complaint. Whether this is going to be even admissible at trial is another story. But it is an example. I sort of wish they had more recent examples, but presumably their argument is the tournament operators are actually sort of happy with this. You know, they're not Larry Ellison. They're not, well, actually some of the tournament operators are the equivalent, but, you know, they would just as soon pay the players less and rake in the money more and not find themselves in the position of other wealthy owners of teams, or in this case, tournaments, that actually have to compete to put together the best. So the fact that we don't see more recent examples doesn't show that there isn't price fixing. But on the other hand, you don't have a nice example like you have in that case of a tournament operator that was trying to compete this way but couldn't.
The players also complain about this 11-month grueling schedule, which they say damages players' bodies and prevents them from competing in other events.
Well, I'm not sure this is an antitrust violation. Sounded more like a labor law complaint to me in a way. You know, I think it goes in there to show that what the public may see as sort of privileged high-class athletes turns out to be a rather grueling job. I mean, they're not coal miners, but there's an aspect to this that the public doesn't see, and I can understand the plaintiffs wanting to get that in front of the judge and eventually in front of a jury if they can. But whether this is actually an antitrust violation, I'm not so sure.
So what do you think is the strongest antitrust claim in the lawsuit?
Well, I think the strongest claim is the collusion or cartel claim, that these are, you know, competing parties, various tournaments that have gotten together to divide up markets geographically, to control the sport, to control the ability of other tournaments to enter and compete for talent, to control what they have to pay the talent, and, you know, to run the sport in their favor. And there are a lot of competing tournaments amongst the defendants. You know, usually competitors have a problem when they get together and agree. Now, it's a little different maybe for sports where there's an idea of a circuit or a league. You know, that's how you get fan interest. Everything's not a one-off. But the basic idea that this is a cartel, and a cartel with power in the market because they've excluded other tournaments. It's very hard to become a sanctioned tournament. So, you know, that core of the case, I think, certainly will survive any effort to dismiss the case outright. But then we'll see what the justifications might be and, of course, what the defendant's response is, because they have yet to file anything in this litigation.
Right. So they've disputed the claims, say they worked to expand compensation for players. I mean, do you see what the defense might be?
I think that, their basic defense is the defense of all these organized sports. We can't play tennis individually. You need competitors, and that means you have to deal with others. So to put together a league, a circuit, tournaments to appeal to fans requires some joint effort. And remember, a lot of this money is broadcasting money. People don't have to watch tennis. They can watch golf. They always argue that there are lots of substitutes. I'm not sure that's a great argument, but they'll argue that. But basically, they'll argue there are good justifications for what they do, for how they come together, and that gives them certain ability to manage the sport in a way that attracts capital, that serves the fans, consumers, after all, it's consumer interest, and also is in the interest of the players, except for the 250 is claimed players who don't seem to like what's going on or just simply want more money.
Does it make a difference that the top players in the sport are not among the plaintiffs?
Yeah, that's very interesting. I mean, legally it doesn't make a difference. This is a suit. It's styled as a class action, meaning they're bringing on behalf of all tennis players, which they claim are sort of similarly situated. So in that sense, it really doesn't matter. On the optics of it, it's sort of good and bad. I mean, it does serve to highlight the disparities in this sport between the very top people who are pretty well paid and the majority of people, who they claim are living out of their cars. On the other hand, the public loves to see the names they know behind this. So Michael Jordan's name features prominently in, all the stories about the NASCAR litigation. So I don't think it's going to matter legally, but I think, in terms of the dynamics of the litigation, it may make some difference.
They're seeking a jury trial. Do you think that this will get to trial or, they'll negotiate, there'll be a settlement?
So most cases settle. Most lawsuits, and certainly most lawsuits in federal courts, settle. So if you want to predict in an actuarial sense, you would predict settlement. Whether this case will settle, I have no real idea. But certainly it might, in the sense that I'm not sure the players want to blow up the system, because I'm not sure what would really be in its place. They do benefit from not having every tournament be a one-off, I think. If there's some ATP tournament, some sort of circuit that you build up points, that everything's not individual. So I'm not sure that they would want to blow this up. So that might indicate that some sort of settlement would be what the plaintiffs might like. But, now as a class action, well, we're a long way from that, shall we say. If it is certified by the judge as a class, then they have to have a settlement that the judge approves as being in the interest of the class. So it becomes a little more complicated.
It always does. Thanks so much, Harry. That's Professor Harry First of NYU Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.